and one nation, under God, indivisible, with liberty and justice for all.
The screen is down.
That went to the highway for training.
Okay.
There's Bronwyn.
Andrew Benson,
Here,
Doug Day,
Here.
Bronwyn Lumsey,
Here.
Joseph Wetmore. Joseph, are you there? No. Okay. Ed Levine.
Here. So item 4 on our docket here is the moratorium discussion, and CJ has prepared a presentation for us. And I'm going to turn it over to her and take it away, CJ.
Okay, great. Well, thank you, Ed, and thank you, town board members, for being here tonight. I prepared just a very brief overview of the planning and zoning and permitting process. And hold on, I'm admitting Joe here. So, all right. Also hosting here. So, okay. So I hear a little bit of feedback. If you would, Ed, if you would please just mute the. There you are. So, yes, thank you so much. And just to kind of speak generally on this evening, I thought it might help to take a step back and kind of think about our processes more generally. So here we have planning, we have zoning, and we have permitting, right? And so in this vein, we have the comprehensive plan, as you know, the town board adopted in 2018. Any other plans that might be relevant? There are some other foundational documents that the town has, and the comprehensive plan essentially is a suite of plans. It's not just a single sole comprehensive plan, but it's others as well. Those play into the role of planning. There's an awareness of current trends and market conditions, and of course the land use audit, which the planning board has been working on, and even virtually over the last year. From planning, we develop, in many municipalities, we develop zoning. And the job of zoning, as we've frequently spoken about before, helps balance private property rights with the public interest. And it also helps manage those development expectations. You know, what are people expecting when they come to the town to build a home or a business? You know, what are they, what's the expectations? You know, are they clear? And then permitting is kind of, you know, where it all comes together. The built environment is where you really see this is the physical evidence of essentially your planning and zoning process. So it's the kind of the fast forwarding of all past planning and zoning work, so that you can really see, in essence, what you have in the end. So, and I say appropriate here with a little asterisk because that, of course, is fairly subjective, but the built environment itself is not. It's pretty clear to see what's being built. And to that end, you know, these documents, you know, hopefully look familiar. The town board adopted these in 2018, and these are available on the town's website fairly prominently. And of course, if you can't locate them there, you can always contact us. But, you know, planning is, you know, more than just a comprehensive plan and just more than kind of all those foundational documents that are, you know, adopted and put on the website. It's about being aware of everything from housing, emergency management, economic development and tourism, coordinating utilities, transportation and energy. So, and I put energy, you know, with a little asterisk here because, you know, it's really incumbent on the town at this point, as we know, The Office of Renewable Energy Siting just today released their new regulations, and that's very exciting in many ways, but also, something that we kind of have to stay aware. We have to be aware of many different things that are happening both at the local and the county level and the state, and also the federal level, to kind of understand how that might impact the town. We have to be assessing the existing conditions fairly regularly. At some point, visioning and creating regulations based on the planning process, understanding what the desired degree of change is. And then, always procedures are changing, laws are changing, regulations are changing. For instance, in the last few years, there's been major changes to SEQR, the State Environmental Quality Review Act, as well as the state stormwater laws. So we have to be on top of that as well. And that's all really baked into the planning process. Now, zoning, on the other hand, is the development regulations. As we just walked through that kind of planning, zoning, permitting process, this is the middle piece. This is the development regulations. What uses can you do? Where can you put them? How big could the building be? Where is it positioned on the lot? And sometimes zoning does include features, specific architectural detail or styling, and even mandated types of materials, for instance, or materials you don't want to see. And that process, of course, is outlined as part of zoning, and that's for all new development or redevelopment and subdivision of land. And it also, any municipality that adopts zoning must also have a zoning board of appeals to be able to provide relief from situations that may not be applicable to a particular project, or just that an applicant is looking to do that they think may be innovative or different, that they need essentially an exception, or what we know is a variance from the zoning regulations. So there's a little bit of conversation, especially in the comprehensive plan, has a fairly shall I say, repetitive mention of form-based zoning. So form-based zoning, I think, can be broken down fairly basically by just taking kind of our basics of what we have now. So we have our zoning map here. This hopefully looks somewhat familiar. The administration pieces, so how it runs, what it is, all its processes, as well as the uses, right? Like what uses are allowed in the town. And when we form-based zoning, generally speaking, doesn't completely cast aside uses. It can in some instances where form is deemed by a municipality to be more important than uses, or completely completely dominant over uses, by really getting specific about the types of buildings that would be built, and what the block and streetscape structure would be, as well as very generally very specific site development standards about landscaping, fences and walls, lighting, parking, and the like, some of which we already have, of course, but can be developed further, as well as rules about frontage, how you're essentially defining the space between, in this case, it says pedestrian travel way, but that can also be the rest of the thoroughfares. So that's kind of a very reduced, shall we say, explanation of form-based zoning, but that generally covers it. So I've received this question lately, how do we update the zoning code? Well, one of the first things that we started with the planning board about a year ago was conducting an audit of existing conditions and regulations. We have so many. I mean, we have zoning, of course, but we also have a broad swath of other land use regulations, from floodplain development to the aforementioned stormwater, subdivision regulations. And so we really drilled down and starting to ask a lot of questions about, what the planning board wants to see changed, what do they like that's working really well, what do we want to add? And from there, of course, we have a whole series of steps that allow us to then update the zoning code and land use regulations from public meetings, the actual writing of the zoning. And as you may have seen in some of the previous slides, we would hope for something that was really graphically enhanced. So bringing in folks who can help us with graphic enhancements to the zoning can be really helpful. And I think that's a really big difference now between kind of past zoning, say the mid-century kind of a look at zoning as, uses are here, minimum parking is here, and kind of turns it on its head and really brings some of that text to life. That's one thing that I really am excited about in terms of revising the zoning here. And then, of course, review by town board. Town board is here and they obviously make all the decisions about the final language that's in any of the local laws. And then, of course, we hold public meetings and hearings. We do environmental quality review. And then finally, and hopefully we've had some conversations with them all along, we would send this to county planning for their review under general municipal law, and they would, give us some feedback, and then we could adopt. So another question I hear is, what is a moratorium? What does that mean? So moratorium, essentially what it does is take these rights, these property rights that are baked into a piece of land that you buy. And Attorney Tour of the town can explain this a little better, I'm sure. But when you purchase a piece of property, it comes with essentially kind of a bundle of rights, right? Sometimes there's mineral rights or air rights. And in this instance, what we're talking about is development rights. So we would be talking about the temporary suspension of those development rights for a specific duration of time so that the town board can step back along with assistance from the planning board and other relevant committees and councils to consider these new rules and strategies. So the thing that we'd want to do, of course, is tie that to a valid public purpose. Why would we be enacting a moratorium? We'd want to talk about the scope of activities that would be affected, as well as where in the town that would be in effect. And of course, we have to follow the same kind of procedures that we do when we adopt any local law. And we also have to provide that similar kind of relief valve, just like we do when we were talking about the zoning previously. So as in the Zoning Board of Appeals. Oh, went back instead of forward. There I am. Thank you, Dan, for that photo. That's me. I'm CJ Randall, and I'm the planner for the town of Lansing. And I encourage you to certainly reach out to me with any questions. I do get a significant volume of emails, so if I don't answer right away, doesn't mean we haven't received it. But of course, you can also call, and we do our best to return calls promptly as well. So that's just kind of an initial overview of planning and zoning and land use moratoria, and hopefully you found that interesting and helpful.
Anything to this?
Say it again.
Guy? You want to add anything to this?
Well, I mean, only insofar as there are a fair amount of legal criteria that appertain to a moratoria, because zoning itself is secondary to property rights. So any ambiguity in zoning as a matter of law is construed against the municipality in favor of the landowner. And the rules are very, very different when you're dealing with non-allowed uses versus allowed uses. And all of those come into play on some pretty key questions in moratoria, and that is, what is the scope and impact of the moratoria and what is its duration? Now, there are moratoria that have not made it to a year and failed, and some that have made it past 5 years and succeeded, the latter being remarkably rare. The general rule of thumb, largely accepted by even the state of New York and most municipal attorneys and the Planning Federation, is that you really should plan for your moratoria to be no more than a year long. It can be extended for just cause, but that requires a demonstration that you have made material advancements, that there is still a proper reason for the moratoria, that you have been diligent in pursuing the goals outlined to be achieved during the period of the suspension. And again, you have to have the relief valve. So the impact is not uniform and universal, and 1 year is a rule of thumb, and it turns mightily upon the complexity of the matter that's under review. So if it concerns one small geographic area or one particular storefront, you're not going to get that long to address it. If it concerns the building of the brand new stadium and an entire 60-block neighborhood in Brooklyn for the Nets, you would probably relatively easily get more than a year, considering that land acquisitions or rights alone would take longer than that. So there's this balancing test, and unfortunately, it is not possible to predict how it would turn out if challenged, because when in doubt, property rights win. So what the town would have to do is very clearly articulate what it is doing, why it is doing it, and document how it is making consistent and steady progress. I am sure that had a moratorium been imposed in February of 2020 with the shutdown of most public buildings and an awful lot of businesses and levels of state government in March through June or July of 2020, that standing alone might be an extraordinary circumstance that would allow an extension. So that's unrelated to the land use, but those are the type of things that can come into play. So to me, one of the first steps, as CJ pointed out, is what is it what property rights are you seeking to suspend, where, and for how long? Those are the three crucial questions. And overriding all of that is the ultimate question, and that is a moratorium even necessary in the first instance? And that question, along with the other determinations, are more so policy determinations than legal ones. I can provide guidance upon what might work, what might not. I've provided a lot of input on moratoria generally in a lot of municipalities over a lot of years. And to my knowledge, one hasn't failed yet, but also if they're properly crafted, i.e. they arise because of an unanticipated situation, a non-foreseeable risk or problem, and they are, properly tailored, they have their relief valves, they're properly sunsetted within the requisite period of time, and they don't, substantially take away someone's property rights, then there's not usually a strong basis to challenge, and they would survive a challenge if made. So the one piece that CJ didn't discuss that was on her sheet was the moratorium itself cannot affect a taking, because if it does, then you're not looking at a zoning issue, you're looking at a Fifth Amendment issue, what's called inverse condemnation or unconstitutional exactions or conditions. So those are the types of pressure points that you need to A, avoid, and B, if there's a risk, document the heck out of the public purpose behind the temporary law. And, that would basically be my input for now. I think probably if the board wants to discuss merits, demerits, concerns, locations, types of things to be prohibited, whether or not this is necessary, and work towards a list of questions, if they're specific to this moratorium or any particular land use application that might be impacted by this moratorium, then I think those specific legal questions, as opposed to general discussion, would be more appropriate in closed session as direct legal advice upon a law that hasn't even yet been drafted. But again, that is your decision. You're the board.
Sorry.
Go ahead.
Go ahead, Joe.
Guy, can you give some examples of public purpose that might be used in a similar situation to the things that we're looking at, just so people get an idea of what you mean by public purpose, what would work as a public purpose, and maybe some contrary things of things that might be mistaken for a public purpose, but really wouldn't rise to that level?
Well, I can, and the examples going each way are legion. They basically turn upon the exact same standards as zoning regulations and conditions themselves. So What is zoning? Well, it really is born of the originally of the power to control nuisances, the police power of the state to protect public health, safety, and welfare. Public weal, if you want to use an older term, because weal also includes the protection of citizen property rights and values. So I like that term better. So if zoning is anchored and moored properly to the police power, the proper subject matter of zoning, then generally it will be upheld, and so too will moratoria. But moratoria, because they're a taking of property rights, have some additional restrictions on them. In other words, they need to be public in nature. They need to be general. They cannot be invidiously targeting just one land or just one project, and not even often only just one use. There are rare exceptions. Hydrofracking, an awful lot of the moratoria that were drafted for that covered all sorts of mining, not just one type of mining. And some of the more cautious municipalities decided to make a broader statement against all heavy industrial operations, not just the one. But at the end of the day, that turned on home rule. So a common example of a reason that you would enact a moratorium is you have an area of town that was previously fully developed, and an unanticipated flood wiped out $2 million worth of building and 42 homes and 23 businesses. And people say, I want to rebuild on my exact footprint. Well, the river just relocated its channel. That might be something you need to take a look at. Doesn't mean at the end of the day you won't allow it. It means you want to take a look. Anything that is, I want to hesitate to just blankly say anything in the comprehensive plan, because comprehensive plans are aspirational and they're equivocal. So if you want to say we don't want large developments anywhere in our town, you have to balance that against the fact that a comprehensive plan is not only supposed to deal with local, but your region, and also is supposed to provide employment and basic services that are needed for residents. So the fact that a business might be too big or in a wrong location, a comprehensive plan standing alone doesn't really address that per se, because if you flip the script, well, but the comprehensive plan also wants places where people can be employed in town and create communities where people can go get services on a walkable basis from nearby facilities. So in the end, it really is a balancing test, and that's why I suggested it's a policy decision. So specific to some situations where moratoria have generally been upheld, i.e., a community is in the process of completely revamping all of their subdivision regulations. They've been working on it for a couple months. They're getting their committee together. Their planning board has started drafting, and all of a sudden they get word that 3 gigantic subdivisions, and of course that's a relative term, 20-unit subdivision in Lansing certainly would not be gigantic considering we got some 80 units, but it might be gigantic in somewhere like the town of Diane. They might say, well, wait a minute, we're in the middle of doing this, and if we allow, 150 acres out of, 3,000, 10% of our land stock to be subdivided before we adjust our regulations to deal with things like roads and water lines and stormwater, that'll defeat the whole purpose of doing a subdivision. So let's put it in neutral. So there's always a tension between where you are and what you see prospectively coming that you feel may constitute a risk. If you are in the process of a zoning review, then it is defensible to in place a moratorium. If you recently adopted a comprehensive plan and it envisions new zoning in a particular neighborhood, and then it is reasonable to make things stay in status quo and stand still until such time as those new regulations are in place. But again, with a moratoria, you're still looking at geographical scope and the duration issues, and making sure that what you're tying down is tied to not only the police power, but the changes you actually envision. So if you said, well, for example, we're thinking about putting in a riparian stream buffer overlay district, and therefore we are going to prohibit the building of the issuance of any building permits for any single family homes on a townwide basis. Well, your underlying purpose may be valid, but your way of trying to achieve that purpose is probably overstated, particularly for people that are nowhere near a stream. So again, where the risk comes in and where the risk can be mitigated either by careful thought, careful planning, or careful legal insight is making sure that all of those different disparate pieces are properly connected. In other words, all the whereases in a resolution do serve a purpose, and in a moratorium, you probably have a lot of them in your adopting local law.
Okay. So you sent us a variety of different examples, and I appreciate that. I'm sure all the board members have read it, but maybe some of our audience hasn't. And it seems to be a kind of theme through here. It talks about police powers. It also talks about on here where it has when utilizing the police power to restrict public activities, the municipality must show that its determination has a substantial relationship to the public health, public morals, the public safety, or the public welfare. Also says under the general police power, a town may enact a moratorium on certain activities as long as it is a reasonable, necessary, and limited response directed to redressing a genuine crisis or emergency. To use your example with the subdivision, what if no one knew about the subdivision and they were going through the zoning, all of a sudden they were aware of it because it came to a public meeting, all of a sudden they slammed in a moratorium? Would that perception be viewed as reactionary?
It could. It depends on the panorama of surrounding circumstances. Was where are you in the process? Was the reaction or the scope of the law in response to, using the vernacular of the courts? And I think you're referring to the Jeffrey case, by the way. But using the vernacular of the courts, was the board merely responding to pressure from an articulate minority or even a majority? Because again, it's not the property rights of the town per se that are under review or that are being restricted or, worst case, potentially taken. It's the property rights of the people in the area where the moratorium will be applied. Those are the rights you're trying to protect and make sure that there's a connection. So, in the circumstance like that, a lot would turn on it. But yes, timing can matter to a court that reviews it, because there is, as I've discussed before, a catch-22 hiding in the moratoria standard. On the one hand, you have a very limited amount of time that a moratoria can survive. On the other hand, you wouldn't want to use up that valuable limited time until the emergency was patent. So I did face a challenge at one time on a moratoria where the developer, and it involves a certain type of variety store that every judge in this state has seen millions of requests for moratorias on. I won't mention the name of the company, where the developer said, but you've decided 2 years ago to update these regulations and you didn't put the moratorium in place then. So, what suddenly makes it an emergency? This one application? Who are you kidding? This is targeted at us. And my response was relatively flat and simple. And my response was, that is a perfectly valid argument you can present either to the town board, to the zoning board of appeals if you wish to seek a waiver, or to a court. But at the end of the day, until there was an application in the door, it is not that unusual to not have a moratorium in place until the risk materializes. So you're sort of, in terms of a developer attack on a moratorium, there's always an argument to be made. You should have done it 3 years ago. Well, if you had done it 3 years ago or 2 years ago, then your time would have already run out. But if you didn't do it and you do it now and the court says, well, that's reasonable, then they can argue, yeah, but obviously if they waited 2 years, it wasn't a high enough resource priority. it's only a big deal now. So there's not a single answer to that. It depends on the plethora of the circumstances, but generally speaking, as long as you are staying within the police power of zoning and the rational basis for the moratoria is properly articulated, then you should be able to overcome a challenge that it is invidiously aimed at one use or one neighborhood or one person. What you need to do is avoid creating a record that suggests that what it is. And unfortunately, when you react to a particular application, whether it's proposed or whether it's actually arrived, it's unavoidable that you will have to answer that question.
So let's take it one step further then. Let's look at from the perspective of the landowner for the subdivision. So they're going to sell this land to be subdivided. And all of a sudden it comes in, they change the zoning at the last minute because they don't want that subdivision there. And the landowner, now all of a sudden, I believe it's called, you mentioned a taking, which means he's taking his property rights away from him. Almost like a spot zone, but the opposite, where you don't allow it, you prohibit it. What recourse does that group have that own that land, or that person has, when people were they're going to do the subdivision had shown interest, it becomes public, then all of a sudden it's taken away from them before they have a chance to pursue it.
Okay, well, there's a lot of questions hiding in there. The first one, spot zoning. Spot zoning can either be a pop-up regulation to allow something or a pop-up regulation to disallow something. So that door swings both ways. What constitutes a spot zone is not always easy to identify, but basically what it is something that's done for a particular individual or very localized benefit, as opposed to being done to serve the needs and ends of the comprehensive plan or the public at large. And where that line gets drawn, well, we can debate it, but the judge decides. As far as the underlying question, whether or not there's a taking, there's a lot of standards that go on that, and there's some sort of generic, you have to take all or substantially all of the value or some substantial property right before there is a taking. But that's not necessarily the standard when you deal with something called inverse condemnation. So for example, if you have a valid basis to increase setbacks and buffers and move all the development only into the middle of a piece of property, you then say, well, but there's a wetland, or there's important, dune grasses that grow there, so you can't develop there either. Doesn't matter if you took or didn't take all of the value. The reason for the denial, the reason for the conditions is itself improper, and that can constitute a taking. So there's not a single calculus. The final answer ultimately turns down to, in order to have standing to make a claim, and hopefully they don't make it federally, because then you get into a whole different ball of wax under 1983 and 1988. But if they make a taking claim, in order to have standing to assert that claim, they must in the first instance have a vested right. Now, a person who is coming along to buy land as a subdivider, subdivide it and either build and sell, or put in infrastructure and sell individual lots for a profit, they don't have an approval. And in many cases, they don't even own the land. It would be very difficult for them, assuming they haven't invested a lot in the ground already, i.e. like mining permit rules, to say that they have a vested right. The underlying landowner, who already has the right to subdivide and the right to sell his or her land, or its land, it might be an LLC, might have that standing. Whether or not it would constitute a taking is again going to come down to, is there a valid purpose? Is it of a proper duration? And is there a proper relief valve? Can they get relief if the impact on them is invidious and very harmful?
Okay, so one more question here. With the subdivision, let's say it's an existing apartment complex and it's fallen down, right? And it's condemned. And a new company wants to come in and build another apartment complex very similar to the business that was there. And because it's in some sort of, because it gets rezoned out, they can't do it once it's made public.
That question would turn on the congruity, i.e., is it in the same footprint or substantially the same footprint? Is it a continuation of a prior use such that the non-conforming use rights would allow it to be rebuilt, even if you tried to zone it out of existence? So I think there are a lot more germane questions there, but the answer is that would present substantially more risk for a municipality because you're dealing with something that already has vested rights in infrastructure in the ground. It has proven its value as an apartment building. And now for that owner, you've taken away that use. So the question of, have you taken away all or substantially all of the use or the opportunity to make a return on investment on the property? You could debate that, but at the end of the day, it was an apartment building, and usually you're allowed to continue it, particularly if the loss is due to an unforeseeable catastrophe, flood, fire, tornado, act of God, etc. But your point is valid in that the closer you get to a vested right, the higher your risk. And there's the same proportionality rule for moratoria. Nobody can tell you in advance how long it might survive, but it is true that there's an inverse relationship between its validity and its duration. So again, the ballpark rule of thumb is a year should be your maximum planned initial level, absent unusual circumstances.
So when you sent us these case studies and everything, were there settlements also in here or not?
Were there what?
Were there settlement amounts also in these lawsuits or not? I didn't know.
No, some not many of them were looking at the validity of the moratorium itself, and that, as I noted, was not information on taking jurisprudence, because takings are a completely different area of law, and it would require that someone not just bring an Article 78. It would require that they also bring a parallel action, and very often at that point you're in federal court. I actually just read the City of Monterey case by the United States Supreme Court, where the dune I mentioned is exactly that case, and the developer was awarded $1.6 million by a jury, upheld by the Ninth Circuit, upheld by the Supreme Court. And it was a erodible beachfront in California, and the municipality had a horrible history of invidious discrimination, including reducing the size of the project 5 times and then still denying it. So in some respects, it's a bit of an unusual case, and it points to the worst case scenario, but in other respects, it demonstrates that it doesn't have to be a taking of all or substantially all of the value to require compensation under the Fifth Amendment, because obviously beachfront land in Monterey, California is valuable regardless of whether or not the apartment house is approved on it. So if you want to see what takings cases are, that's fine. And again, the bigger risk there is the federal claims, because even if the taking is de minimis, if there was a taking of a federally protected right, i.e. due process, equal protection, property, then the claimant, even if they recover $1, is often automatically entitled to all of their attorney's fees. So even though you may functionally sort of win the case, you still write a big check. So even in ascertaining how your regulations might work to regulate where you might be sued or why you might consider certain conditions or exceptions. In other words, one of the most sacrosanct property rights is the right to put your own home on your own land. And New York State has recognized this in a great number of ways, right down to exceptions to public highway and subdivision rules baked right into the statute itself. So in a moratoria for something like a scenic overlay district, theoretically speaking, you might want to be careful about taking away someone's right to build their own single family residence, or at least condition it on some standards. But on the flip side of that coin, obviously, a solid waste facility might be something that would be pretty easy to put on the list of things that shouldn't happen during the period of the moratorium.
So I have one more question. How much time and energy and money does it absorb when you're dealing with a lawsuit to protect the municipality? I mean, between their planner and the code officer and the board, whether it be the planning board or if they were involved, the town board, how much time, energy, and money is involved in these things? I mean, are they quickly settled or does it drag out for a long period of time?
The federal claims, no. State Article 78 claims generally, it's hard to say with COVID, but generally have a shelf life of under 6 months because they're usually summarily determined on the papers. But given the number of municipal affidavits and the size of the records, i.e. they often include multiple sets of minutes, all sorts of review paradigms, and the number of issues that you may have to brief or argue are usually legion. The last one I did, ironically, was only a couple of months ago. The memorandum of law itself was 18 pages. Granted, it meets the filing requirements of the courts. That's double spaced, narrow margins, so they can make notes and stuff. But still, that's a fair amount of work. So as a ballpark rule, because I like to sort of jokingly say that litigation is about the most expensive thing you can do in the law, except for perhaps patent interference on pharmaceutical cases, because they take a lot of time and money. They take a lot of effort, and you can't necessarily regulate the risk or the outcome. And you obviously have the possibility of appeal. So ballpark rule, the federal government in establishing the minimum basis for a diversity jurisdiction basically has a rule, and I don't know for sure what the number is right now because federal practice is such a specialty. I stopped doing it a few years back. I'll ride shotgun with someone if they need assistance, like municipal expertise or something, but I won't be the counsel of record. Basically, if a case doesn't have a value of $75,000 to $100,000, they won't even take it in federal court. So that actually it turns out, if you do the quote unquote analytics, pretty accurate. An average lawsuit in state Supreme Court, where there's a genuine contest, not a default judgment, not collecting on a note, with the exceptions of foreclosure, because they're wicked expensive. You should anticipate $20,000 to $50,000 to fully litigate a state court case. About half of that if the Article 78 is summarily determined on the papers, which most of them are. Triple that as a minimum number in federal court. That's a ballpark. And the last 3 Article 78s I did all came in at that number, except for one, which was substantially lower because the only question was whether or not there was a proper challenge to the re-levying of a water district bill on the basis of a claimed faulty meter. And that wasn't even in this county, so don't worry about it. The municipality.
In the medical field, they have, as always, document, and that was always is the benefit outweighed by the risk, and the risk taken was that the only risk you had, or were there other more conservative options that should have been addressed first? And this is one thing we had in our world, in the pharmacy world, when we had drug interactions, is the risk outweighed by the benefit, and are there no other options available? And you had to document it because you had to protect yourself against negligence because of the perception of overreacting. Anybody else have any questions for him? Go ahead, Rowan.
I do. I wanted to just kind of respond to your point, Ed, about risk, and just as we have this discussion, be aware that not taking action might also have risks too, and we should consider those. Guy, I had a question in particular. When you kept saying relief valves in a moratorium, that they need relief valves, what does that mean? What do they look like? Can you explain that?
Yeah, well, they can contain any number of requirements, but basically, just like a zoning law must have a zoning board of appeals, because a one-size-fits-all rule doesn't fairly or equally apply to all owners, all uses, and all land. Some parcels are oddly shaped through no fault of their owner and won't have frontage. That doesn't mean you can't put your house on it. So we have area variances and use variances for those things that are exceptions to the standard rule. When someone can prove, I have a substantial and unique hardship. Okay. So a moratorium generally must have that same relief valve. You set forth the standards whereby someone with a unique situation or hardship can apply for a waiver or to be not to fall within the unregulated side of the moratorium. In other words, it doesn't affect them. Most often, but not always, these are roughly based upon and parallel the standards for use variances, because the moratoria is trying to prohibit certain things from happening. Therefore, allowing something that's within the prohibition to happen is more akin and characterizable as a non-allowed use. So is it a use variance per se? No, but that's why you actually have to fashion the relief valve to work for the particular land and nature of the restriction in place and the land in question. Something that is on the Erie Canal might have a different sort of release valve than something that's in a desert somewhere. So usually, because of the parallel to use variances or variances in general and how the requirements may require different factors to be balanced, it is typical for waivers to be given to the ZBA, but it is not required. It is a stopgap, one-time, short duration, temporary local law, or at least it should be. And I have done moratoriums where the town board itself decided that it was the entity that would hear the waiver. There are good and bad reasons to consider that based on a whole myriad of factors, but those are the things you're going to weigh when it comes time to decide what board or body will be the reviewing authority for considering a waiver. And again, because they do tend to be more like variances, I lean towards the general rule and the recommendations of New York State and the Planning Federation that it be the ZBA, because that is their field. But it's not required. And if that's a point of further discussion, that's part of what you do when you start building the mechanics of the moratorium.
Thanks.
Any questions? Okay, I'd like to move into closed session, but I also like to move in executive session too. I'd like to do the executive session first.
Well, Ed, for more questions, Joe did raise his hand.
Oh, I'm sorry, Joe, I didn't see it. Go ahead.
I would like Guy to talk a little bit about the record that the town could produce and what kind of things are, valuable in a record. Give some examples so that we have an idea of, when you say in order to do a moratorium, you have to build a record showing that you're doing this for a public purpose for the townwide value. How do you build a record like that, and what type of things would be optimal in a record like that?
Would this fall under legal advice?
What's that?
Would this fall under legal advice?
It could, but I'll answer it generally, and if we want to get into specifics later, we can, if that's okay.
Yep.
Generally speaking, what you're talking about in terms of making a record is explaining why you're doing what you're doing and how it relates to public weal. And normally part of that is to recount specific historical events, i.e., when you updated your comprehensive plan, what you have been doing in order to implement these new regulations or this new scheme. You want to show no gaps in time, no unreasonable delays. You want to basically tie everything together. So creating that record is not just a matter of affirmatively avoiding the missteps, but it's also a part of affirmatively creating the history to show that there has been a steady and continuous course towards a particular goal that could now be materially disrupted. And there's always a tension between, one of the things that happens is what you're really doing with a moratorium is looking at a regulatory scheme. And one of the grand ironies that can come back and haunt you is at the end of the review period, and by the time you adopt the legislation, the use is nonetheless still allowed, or still allowed. They just have to move 50 feet further away. That's a tough one, because then you go back to the heart of the question, and that is, was it necessary in the first place? So if it's going to take you 3 months, $5,000 and 600 man hours or woman hours to enact a moratorium, but it's only going to take an extra 100 hours, the same amount of money in an extra month to enact the regulatory change you want, then why would you use all those resources on the moratorium? Why wouldn't you just go for the regulatory change? Because technically speaking, unless what's called the special exception circumstance applies, the law that is applied at the time a court reviews it is the zoning that's in place at the time of the review. And that includes appeals. So that's one of the factors that the town needs to consider more closely, probably in closed session, is what are these competing timelines? And is there a reason to put a lot of resources into a moratorium if the zoning change that's envisioned could be done in a similar amount of time? Don't know the answer to that. I'm just saying that I've seen a comprehensive plan completed within 6 months of a moratorium that was set for a year. And there was no need for a moratorium if all you were doing was completing a comprehensive plan, because a comprehensive plan is not regulatory. So I've seen some pretty weird ways that this can play out. But as you all know, from the last 7 times this issue has come up in 4 years, I dislike moratoria, and most attorneys do. They take a lot of time, they engender a lot of risk, but the other side of that coin is sometimes they are the correct tool for the job.
Rowan.
I have a question, and I don't know if now is the time or place for it, but it's about sort of what can be done with zoning. Some like specific types of zoning that I've heard about, and is now a good time to talk about that? Because I feel like it speaks to, can we just zone whatever solution we want very quickly or something like that?
Well, CJ may be the more appropriate
Yeah.
person to answer that in some respects, but to the extent that she wants to defer to me on something that's more legal than planning based, I'll fight back in.
All right. So CJ,
Yeah.
the idea of some towns that do like an economic impact review as part of their zoning or planning or to allow things to be built. Can you just talk about that? Am I totally off base? Like, what is that? How does that work?
Okay, in terms of, I guess I need just a little more information. And is that kind of related to the tax implications of it, or
sort of like how it would impact the economics of the town, how it would impact things generally?
Okay, so
because like there's usually an environmental review if it qualifies. Like, can we as a town say we want an economic review before things are built, or is that a possibility?
Okay, so and this I'll probably kick the guy on how much you can do this in seeker. I think that's sort of what you're asking, is kind of the what would can the project demonstrate? I don't think what you're asking is the project demonstrating like financial solvency, or
right.
Can they actually? It sounds like you're kind of thinking of maybe the broader view of that. Okay, so that could. Could encompass things like what we've been talking about for the town center incentive zone, for instance, right? So from a broader standpoint. So the first, directing development to areas where it is most financially advantageous to the town, right? So It's kind of one piece of it. We know that generally speaking, it's most advantageous to a municipality to direct growth to areas where there's already existing infrastructure for hopefully what are obvious reasons. Either existing or planned water, sewer, big ones, of course, very expensive, and roads, of course, too, or anything to do with the transportation corridors, generally speaking, more broadly. And so one way to do this, or some kind of, and without knowing the kind of the scope of the impact analysis, I'm just trying to speaking in generalities about kind of the, I'd say overall fiscal benefits of defining the areas where you wish to see growth. But there's also some other types of tools that can be used. And in fact, I was speaking with the county assessor about this not too long ago, about tax increment financing as well, as a way to allow the municipality to plan for and pay for the installation of this infrastructure per se in a planned area, while allowing kind of that gap so that people aren't really hit with a huge tax bill and you're kind of paying it basically over time. So I'm not sure whether you were thinking about kind of the broader version or kind of a site specific or a specific kind of analysis of a specific proposal, but another thing that can be part of an economic impact analysis can be a build out analysis as well. So for instance, stepping back and saying, what does the town look like under full build out? If you took every parcel in the town as it currently existed, minus subdivisions, of course, forget those for just a second. But as it currently is in kind of a static snapshot, and then basically ask, what's the full build out that you can do here? You get a sense of, both development footprints, estimated, cost to provide services, as well as what you could estimate that revenue to be as well. So I don't know if this exactly answered your question, but
it helps some, I guess, and also this speaks to the limits in our ability, right? That we can encourage certain development in certain places, but we can't, there's a limit to what we can allow and not allow. When you talk about like how to encourage, the economic development zone around the town center and stuff like that sort of.
Well, yeah, with incentives are a big piece of it
Right.
too. That's kind of the big question, and I think part of me when I think about economic impact analysis, it usually comes from economic geographers who are trying to estimate the number of jobs that are created for something, which is always a very fascinating exercise. But yeah, that's really when you layer these pieces together, when you think about the zoning and what you want to see, and then you layer that with some other kind of standards, maybe aesthetic standards or form standards, and then the cherry on top can be some of these incentives, either abatements or if you for instance, the incentive zone in the town center says, if you build this type of building, like a commercial structure, or if you provide housing, we really love that as a public benefit. We'll give you an abatement for this many years. When you start to layer those things together and they mesh just perfectly, that's when you get what it is that you really want. Takes a little while, but
Yeah. Thanks.
So CJ, I have a question for you. The IDA, the Incentive Development Area, right? That we obviously just passed a resolution for Saltborn Brewery, right, for their pilot. And we've also had resolutions for the pilot for the Lansing Market a couple of times, right? We've extended that. Is East Shore Drive covered in that area? I can't remember where the area is as far as the boundaries go. I know it's in a town center area, but I can't envision where. Does it go on Trip Hammer Road? Does it go down the East Shore? Where that area ends as an incentive for economic development?
Yeah, and that's a really good question, and that's something that we have actually been examining as part of this is just the clarification of those affected boundaries. Yes, for the most part, it does extend, covers town center and then points somewhat south. And yeah, it would grab part of East Shore Drive. That's recognized generally as part of town center. Yeah, and I'll try to find that map while I'm at it.
Isn't that one of the things we're working on, is trying to get an exact map, because the one that was passed before had some ambiguities in it?
Yes, exactly. And so that incentive program was passed, let's see, hold on a second. That was created, here it is. It was created in May of 2011 and it expires at the end of this year. And if I may, I'm happy to just show that map real quick.
I'd like to see it.
Yeah, sure. Hold on just a moment. So this is the approximate boundaries. And I think it would, generally speaking, follow these, kind of these darker double lines. I think, reasonably you could follow this. So that's at present time, this is the general vicinity in which I would presume the town center incentive zone policy to apply, if that helps.
So CJ, how far south does it go? It goes from East Shore onto Auburn.
It looks like it grabs like a smidgen of Drake and then ends like a couple parcels north of Asbury.
I mean the other way. Okay.
I'm sorry. Yes.
Towards King Ferry.
Yes, and then it goes also to.
If you go to Rogues Harbor and you go south, where does it end in that thick, dark area? Looks like it goes up there to the left.
Yeah, so here's the town hall in the area here, and then here's East Shore Drive, and it appears to terminate just north of Asbury, but it could also terminate somewhere around here. So I think that's, you could kind of read this fairly generously either way. So yeah, hence the desire to clarify the map boundaries.
That's helpful. Thank you.
Yeah, sure.
Anyone else have any questions? Okay. I was going to talk about policy tonight also, but I'll leave that for our next meeting, which I think is important. As far as being ready. Go ahead.
May I just mention one more thing? Bronwyn asked about kind of the economic analysis question, and I just want to mention that there's an organization called Smart Growth America, and not too long ago, about 5 years ago, they published a really great study called The Fiscal Implications of Development Patterns, and it's specifically a model for municipal analysis. It does take a bit of the angle that dispersed settlement, single family homes kind of on 2 acres, everywhere, may not be, quite the sustainable model. So with that caveat, kind of read it with that angle, but it's really, I think it really forcefully explains, how you can really look at the different development patterns and kind of see what the end result is from a revenue perspective. So just endorsing that, and I'm happy to send that to the board too. Just as a link you can click on.
Please do.
Okay.
Yeah, absolutely.
Did you have a question, Andra, or you just, no? Okay. Well, I guess I'm going to say this now because I think it's relevant, is that there's a concern coming out here, and I'm very concerned about this. When people in general come to you with concerns and they try to lobby you, the response, in my opinion, should be, I don't want to talk about this now. You need to bring it in front of the town board so we can all look at this objectively. And leave it at that. I don't know if people have pulled anybody aside and hammered on them or whatever, but we're gathering information here and to maintain our objectivity. There's been some comments that have been made by certain individuals, which I'm concerned about if they need to recuse themselves. And one of the things is that rather than be reactionary or try to show support for certain people that you're concerned about this, in my opinion, and maybe Guy can expand on this a little bit, but there is a pattern developing here. If we hoot and holler enough and we send enough letters before it comes to the board, look at this objectively and have these discussions with all the information from us first, that perhaps we've already made our decisions. You want to expand on that, Guy?
Well, to a certain extent, only because I've already said this before, but there are a lot of municipalities that basically have sort of standing rules that their various board and committee and other members don't engage in public discussion around the mailbox, the water cooler at the grocery store when people want to speak for or against a proposal, whether it's the subject or not the subject of an application. And that's for a couple of pretty standard and well-defined reasons. And of course, thought police are not something that you should be empowered to do. But the two main reasons to avoid that are, one, it avoids bias as well as the appearance of bias. I.e., if every single coworker and every single neighbor comes up to you and says, I think a hotel in that location is horrible, and I'll unfriend you and I'll browbeat you till the end of time if you vote for that, that has an influence whether you think you're immune to it or not. Worse, it creates the appearance of a bias, i.e. you've been influenced, and more importantly, at a time when an application may not even be in the door. So avoiding the appearance of bias or a conflict of interest by taking a position or saying something innocuous and having it interpreted as he or she is for or against something. You're allowed to have opinions. That's what you're elected to do. But prejudging something is a whole different can of worms. So there are a number of municipalities. They tend to be larger and more urban, but let's face it, there's 3 municipalities in this county that are becoming larger and more urban and need to be worried about this kind of stuff. That say the general answer should be something akin to, I really appreciate your input, but you should bring that to the attention of the Conservation Advisory Council or the Planning Board or the Town Board in writing or during their public hearing on this matter. You don't shut the person off. You just say, I'm not supposed to discuss that in a situation like this. The second reason that there is a general consensus that having some standard in place is appropriate is because, again, you're regulating the land and property rights of the applicant. And ZBAs have to follow this rule much more closely than other boards and commissions do. But the short answer is that an applicant is entitled under the basic mandates of due process and equal protection to be able to, hear, meet, and respond to objections, challenges, complaints, and impacts. And if there's a general, if someone has a general, if there's general rumor, general innuendo, a general impact upon the reviewing board, whichever board that may be, prior to the time before an application even comes, how is it that the applicant ever has a fair opportunity to see what those objections were and to be able to try to answer them? So you've got a basic due process fairness question hiding in there. And again, it doesn't mean you can't have an opinion and you can't talk to people, but there's a line. And ZBAs have to be far more careful about this than planning board and town boards because they're actually acting in a judicial capacity. But the underlying concept of avoiding bias and due process, they apply to all reviews. So there are reasons to maybe start looking at, in not just as a matter of looking at zoning, but to look at other policies as well as to how matters like this, i.e. that which triggered this special meeting, come before the town board, or in this instance, why isn't some of this really literally in front of the planning board as well, since they will be now or later a reviewing authority either on the moratorium and on the local law or on any project application. So there are layers to this kind of stuff, and I'm not gonna say, you know, I certainly don't think you should have a lockdown. Citizens have a right to petition government, but that right is not unfettered, and it can't occur wherever and however citizens so wish. There should be a channel for that to happen in a way where it's fair. And for an applicant, fairness means they're present, that they have an opportunity to hear it and at some point respond. And
In all fairness too, I mean, people can communicate by letters if they want to send them to the boards. That's fine, once they bring the issue up. But in all fairness, to be objective about it, if you get 40 letters that say we're against something, there may be 1,000 people out there that want this, whatever this is.
maybe, yeah.
And, you know, then the problem is, if you've already, once again, I'm not accusing anybody of anything, but I would like the process to be, rather than backwards to the front, I'd rather be to the front to backwards. Get the issue out in front of us, okay, as far as this is concerned, bring it to the attention of the board, and then go from there, as opposed to having something that is perhaps the perception of being reactionary. Go ahead, Joe.
So are you suggesting that I shouldn't put on my Facebook page a post saying, hey, Lansing, what are your thoughts on current development?
I know you're making reference to me. No, not at all. That I use that as a way to communicate to people.
Yeah, but doesn't that get people talking to you one-on-one, which is what you're saying you don't want people to be doing?
Well, they can share these thoughts, but you make a very good point. Maybe I need to stop doing that. But on the other hand, it's a way for me to communicate to people, and maybe that is a privilege of the floor. No, that's a very good point that maybe I should reconsider that. But on the other hand, how do you communicate to people what your concerns are? And maybe I should do this the opposite to your point, which means you need to come to us. And I don't mind doing that. I don't mind as far as that goes. And let them come. One thing I did not do, and this last time, is to say, hey, Lansing, do you want a blank, blank, blank or not? And I think it's a growing process, and I thank you for sensitizing me to that. But on the other hand, I think if I needed to take this first step forward as the leader, that's fine with me. I'll just use it as an information source to say, power's out, hopefully be back in 3 hours, as you do, right? When you do your Lansing email. Also on that email, in all fairness, was an email blast of here to write the letters to everybody, here are the talking points. So do you need to censor those things also on your email? Because that's a concern also, that we're propagating this. And maybe these things need to be shut down. It's a great way to do information when you're talking about, geez, the bridge is out today. We have concern about that. And I think you and I are in a similar area. But when somebody puts on, who perhaps lives in the same house as you, or you put information on there, is it something that's relevant to the town's safety, like the town hall is closed today? Or is it the fact that someone puts something on that email blast? Here are the talking points. We need to get this going. We need to stop this, whatever this is. There's a fine line there, and I understand it may not be you, but it may be somebody else that perhaps is in your same house doing it. Is that the line? I don't know. Do we move across that line and say, if it's coming from your household, we shouldn't do that? I mean, I'd love to have that conversation, because I know there's a lot of emails going behind everybody's back, going back and forth as far as what they should do, but those are citizens talking to each other. And to your point, the elected officials, I have no problem not doing that anymore. And I'm going to be able to do that now, because I think this is an action that needs to be taken so we can hopefully prevent some of the things from happening in the future and go back to a much more objective process, which is, okay, you have a concern, privilege of the floor. Okay, CJ, let them in, let's hear about it.
I think that part of our job as elected officials is to listen to our constituents. And I think that when a constituent comes up to me and wants to talk about something, that's perfectly valid for me to listen to them. I also think that it's part of my job to explain to citizens how things work. You know, what's in a comprehensive plan? How does a comprehensive plan work? How do you move forward? If someone comes to me and says, is this an allowed use in this zone? I think it's reasonable for me to look up on the zoning map and the ZBA and say, here's what I'm seeing. This is what it looks like to me, as opposed to, having CJ or someone do it instead, because I can run them through a lot of the easy stuff. I mean, there's certainly points in
Well-
which it's a judgment decision. And I think that's my responsibility as representative, is to answer questions and help people with the process.
But you also need to encourage them to come in front of the board, because the rest of us haven't heard those concerns, especially when they get rashed up. And that's my concern. And if you're going to follow that road also, if we want to split hairs, then I might as well just keep saying, hey, Lansing, what's on your mind today? I mean, and share. And to put on there, if you have a concern, you come in front of the town board. I mean,
I agree. I tell people all the time, and I think you do too, that you need to come before the town board, the planning board, whichever board is dealing with the issue at hand. And sometimes the answer is you need to go before the county board, or you need to go to the state, because this is not a town issue that you're bringing to me. And I think you're absolutely right.
I understand that. I've seen you give them that advice before, and so have I. And I know it's a fine line, but there's a pattern developing here where all of a sudden we get the email barrage, and it hasn't even come to us yet. And to be quite honest with you, I think tonight's meeting is a result of some of that.
And as the person who initiated tonight's meeting, I very much wanted it as a way to communicate as a board about this issue, and to get some real clarity, like with CJ's explanation and things like that. And I think that a lot of the confusion and questions is related to process. And so I was hoping to clarify that, and doing it one-on-one, where we see sort of the challenge with that, both in where is there a line, when do we cross it? And it's a lot of work were we to respond to every single one of these emails. And so that's exactly why I wanted to have this meeting, was to discuss the process and have it be public information, the process, the parts that can be public. So people can kind of understand what we have control over, what we don't have control over, what it looks like, what we're balancing when we look at concerns.
And I thoroughly understand that, Brown. My concern was, as I said in the email, does this need to be a special meeting, or could this wait for 2 weeks? And the perception is, and you know what I said, it looks like this is reactionary. Once again, these people that sent the letters, it would have been nice if they came in front of the planning board or another board and said, okay, these are, because now we're into moratorium concerns, right? I mean, anyways, I don't want to go into too much detail here. Not that I want to be transparent or more truthful. I'd rather be truthful. But on the other hand, I think we're going to have to move into eventually closed session to get some advice from our attorney. But I'm simply making you aware of and trust me, I may be as guilty as the next person. Maybe I should respond to all those letters saying, you know what? That's thank you for the concern, but you need to bring this in front of the town board directly, not with a letter campaign first. And I know there's a fine line there, but once it's done now, is that if this continues, the time and energy we're going to have to do reacting to all these things, I think it needs to be filtered on which ones can wait a few weeks or a few months, because quite frankly, the reality is, how much time did a planner spend these last 2 or 3 days with a special meeting? How much time did our attorney spend on this? And people wonder why we haven't got our zoning done yet, when we had also to stop the brakes with Asmika. We also had to stop the brakes to review the solar law from the planning board, even though no one's implemented one yet. We just passed it. And how many other things have we been derailed? And you wonder why it takes 3 years to do the zoning and it hasn't been done yet. I'm not throwing stones at people. I'm simply saying that I think the behavior needs to be focused on getting the jobs done. We can address their concerns. We're not going to poo-poo it, but I think it needs to be done in a methodical, objective way.
And just final comment on this thing, because I think we can get pretty far down the rabbit hole here, but to Joe's point, to Bronwyn's point, to Ed's point, there is a right to petition government. It can be done in writing or in person. Both of those avenues are generally recognized and available, and I wouldn't shut down either of them. Joe, yes, of course you listen to someone when they come talk to you, but engaging, responding, going beyond that is what can become or appear to become problematic. But let's also make a very material distinction between asking for something that's very general versus something that's very specific to one project or one issue. It's one thing to talk about restaurants in general. It's another thing to talk about that darn McDonald's that wants to get on the corner. Those are two very different things in terms of the potential for an appearance of a conflict or for being influenced in a way that you may not fully understand when it comes time to review an application when it comes in the door. So there's no one size fits all for this. There are some general policies when you can listen and then say, I think you should put that in writing and submit it to the town, or I think you should say that to the planning board, or I think that's a valid point. Maybe you should bring that up during the public hearing and say the driveway should be located there. There's any number of variations on the theme, but under no set of circumstances should you implement a rule that denies the right to petition government. I mean, that's protected on all sorts of levels, the most important one being morally. So there's a distinction between the general and the specific, and we started to break that line, and where you decide to set that line, if you adopt some type of policy, that's a whole other discussion.
Okay. Anything else? So I have two things. When you go into executive session, pertain to the acquisition, sale, lease of real property when publicly might affect value. And then when we come back out, we'll go into closed session. I'll motion. Anybody have a second?
Second.
Was it Doug?
Yep.
Doug.
I'm sorry, which one did you say?
It's the one about the sale, lease, or acquisition of real property where publicly might affect value.
Okay.
Oh, first.
We have to vote.
We have to vote first, then you're staying for this.
Oh.
This involves.
I assume we're including staff in this executive session?
No, we're going to include, well, if you're saying
Yes.
staff, Patrick, yes. If you're saying, I guess, Munson, no.
CJ too.
Okay.
CJ, I think you should stay. For the duration. So, time to put another pot for your tea, and we'll go from there, or whatever you drink at night, and off we go.
We need to take a vote first.
I'm waiting on you, ma'am.
Okay.
I'm just waiting for that look.
Throw something at him.
Well, she's done that before when I was a little bit, I was first mouse.
All in favor?
Aye.
Aye.
Any opposed?
No. Mrs. Munson, you got up early tonight. Not even 8 o'clock. Thank you.
That was, didn't we start at 6:30?
When you roll your eyes, is that being gracious?